Good afternoon, everyone. Welcome to this week's discussion and update on COVID-19 webinar. My name is Kathy Purdy. I'm a marketing manager at Bond. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows. Also, if you would take a moment to complete the brief survey once the webinar has ended, we would appreciate that, as we do look at your comments and suggestions for future topics. So to start today's program, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be back here with you again this Tuesday. Before we get started, I think we would be remiss if we didn't just comment on the positive news. Vaccine being approved, shipped, and administered. It's going to take some time, obviously, for that to reach critical mass and have its impact, but it's really good to hear that we're moving forward and that there's some, as everyone seems to be saying, light at the end of the tunnel. So with that, we got a full program for you today. We're going to start off with a couple of developments that are a little bit independent of the pandemic, but nevertheless, things to keep on your radar. Starting off with Teresa Rusnick. Teresa's in our Rochester office, and she's going to fill us in on the latest updates with respect to the New York paid sick leave statute. Teresa?
All right, thanks, Pete, and good afternoon, everyone. As Pete said, I'm going to be talking about the paid sick leave statute and some of the more recent developments. I know we've all been eagerly awaiting more guidance from New York State, as well as the proposed regulations, which came out on December 2nd. So I'm going to start with those. For those of you that didn't have an opportunity to catch Bond's earlier webinar on this topic, the proposed regulations did come out December 2nd. They're available on the New York State paid sick leave website. If you scroll all the way down, they're at the bottom. And they did address some of the lingering questions, or at least attempted to address some of the lingering questions that we've had about paid sick leave. I'll go through those briefly, starting with the documentation requirement. There had been an open question about whether employers could require medical documentation from an employee when they use paid sick leave and what form and content could be in that documentation. The proposed regulations say that after 3 days of leave or 3 days of an employee taking paid sick leave when they have a scheduled shift, they were scheduled to work for that time, an employer can ask for documentation from the medical provider. However, the scope of that documentation is rather limited. It's limited to an attestation from the licensed medical provider, which supports the existence for the paid sick leave, the amount of leave needed, and the employee's date to return to work. So that's all you can do pursuant to the paid sick leave documentation from a medical provider. For safe leave and for other types of documentation, if you don't want to get it from the medical provider, you can also ask for an attestation from the employee of their eligibility for leave. We've developed a couple of those forms here at Bond. It's just a short statement basically saying that the employee is taking the leave for a paid sick leave qualified reason and is not taking it for an improper purpose. So that was the documentation aspect of it. The paid sick leave proposed regulations also talked about employer size. I know this had been a topic of some debate, especially if you're an employer who's right on the threshold of having 100 employees, how much leave do you have to offer? How do you count those employees? And the proposed regulations said that you count the number of employees at any point in the calendar year. So that was something that I think still needs further definition. What does at any point during the calendar year to date really mean? There are some examples in the FAQs about an employer, for example, who hired a couple of part-time people for 2 weeks in 1 month. Do those people count? And the FAQ response that they do. So I think generally speaking, it's going to be a broad count for employees. Seasonal employees will count, temporary employees will count. So really, if at any point you cross over that 100 threshold during the calendar year, you need to start looking at as to whether you need to provide more leave either in that year or in the subsequent year. And those are all things that we can talk through with you on an individual basis. The proposed regulations also set forth a number of definitions. We had been waiting on definitions for things like family offense matter and stalking and confidential information and things like that. Most of those definitions are defined by referencing other statutes, such as the mental health law or the criminal law, but those definitions are all available to us now via the proposed regulations. So if that's something you want to include in your policy, that's something you're now able to do. Finally, the proposed regulations, last main category was on accruals. This, I think, is probably the more complicated part of the proposed regulations, where they said that an employee can essentially earn partial accruals of paid sick leave. That is contrary to what we had been understanding the statute and the previous guidance to say, which was that an employee really only gets 1 hour after having worked for 30 hours. These new regulations seem to suggest that a partial hourly increment could be awarded in some circumstances. So again, if you have questions about that, feel free to reach out to us and we can explore the parameters of how that would affect your specific accrual system and your workforce. So that was the quick rundown of the proposed regulations. Beyond that, some of you may have seen that we received from New York State on Friday afternoon late, this past Friday afternoon on the 11th, a series of, I think it was 8 fact sheets geared towards different industries or different sects of employment, and an updated FAQ, general FAQ page. When those first came out, we were very excited because we finally thought New York State might be answering some of the lingering questions we had and, perhaps would really give us some kind of detail. But as I'm sure you can tell from the tone of my voice and the qualifiers I put in front of this sentence, New York State did not do that. And largely, even though they issued 8 new fact sheets and some new FAQs, it really was just an excuse for them to repeat information they had already given us. There's very little, if anything, of significance in those new FAQs or fact sheets, so much to the point that, we were considering doing another pop-up webinar just on them, but there just wasn't enough there. If there is a fact sheet geared towards your particular industry, I encourage you to check it out. It may provide some kind of guidance or help to you, but I don't think overall there was anything of too much significance added, just a lot of extra paper. One of the biggest remaining questions that we still have is on carryover. I continue to still get any number of questions each day about whether or not employers can cap carryover at the 40 or 56 hours, or whether or not they can eliminate carryover when leave is front-loaded, as the New York City Earned Sick and Safe Time Act at least previously allowed us to do. It's still unclear whether or not that can happen for New York paid sick leave. The new proposed regulations do not speak to carryover at all. The fact sheets and the new or reissued guidance in some ways continues to maintain that all leave needs to be carried over if it's available and unused, but that employers can still restrict the usage to 40 or 56 hours in a year. The fact sheet does go out of its way to say this may result in an employee having more leave than they can use, but that's all right because an employer can still restrict use. So that remains our world on paid sick leave. Certainly we'll keep you updated to the extent anything else comes out, but for now, I'll turn it back to Pete.
Teresa, one of the things that we might just talk a little bit more about here before we move on to Suba is sort of the conflicting documentation requirements as well. So we did get a little bit of clarification here in terms of what can be sought and when, but there are still a number of these situations may implicate also the FMLA or the ADA or other statutory schemes. And so I think we're going to have to coordinate and basically reconcile those the different statutory schemes, because even if the New York State PSL is clear in terms of what can be requested, and it may still not be, you're going to have to take into account your obligations, duties, and rights under some of those other statutes as well. Any thoughts on that?
Yeah, I agree with that, Pete, and I think it's a good point. In terms of what or not an employer can require, like, say, FMLA documentation when someone's using leave that qualifies for both paid sick leave and FMLA. I think they can and arguably have to. You know, I don't think there's anything in paid sick leave that prevents or prohibits an employer from requesting documentation that's allowed by other laws. I think when you're using paid sick leave alone, that's where you're going to have to adhere to the paid sick leave specific documentation requirements. But when paid sick leave is combined with another type of statutory leave, be that federal or state, you can feel free to get the documentation required by those statutes. You know, another good example there would be paid family leave. You know, just because you're allowing an employee to supplement paid family leave with available paid sick leave, which is an option you can give employees, doesn't mean that you then don't have to submit the forms to your carrier and get the appropriate documentation from the employee. I think you do. And actually, this reminds me, one more thing I'll mention. The new guidance does talk a little bit, and I think the old guidance does too, actually, about the interaction between paid sick leave and COVID-19 leave. And it very explicitly says that nothing in the paid sick leave law is meant to override or conflict with the New York COVID-19 leave law. So if you have an employee subject to an order of quarantine, they're still going to get that New York COVID-19 law, even if they might otherwise be eligible to use paid sick leave for that time. So that's just something to keep in mind as we go forward.
Okay, I'm just reminded of, this is a complicated statute. I think back to the FMLA, which was, put into effect years ago, and how long it took to sort through all these issues. We're trying to sort through them on a very expedited scale, and there's still a lot of unanswered questions. Turning now, thank you, Teresa. Turning now, we're going to turn to Subha Viswanathan. Subha's in our Syracuse office, and he's going to talk a little bit about some things that may have snuck up on some of us, the New York State minimums and thresholds for the salaried exemptions. Subha.
Thanks, Pete. Kathy, you can move on to the next slide, please. Thanks. So the minimum wages are going up effective December 31st. We thought this would be a good time to remind everyone. Employees other than fast food employees in areas outside of New York City, Nassau, Suffolk, and Westchester counties, the minimum wage is going up to $12.50 per hour. It's currently $11.80, so it's going up by 70 cents. In Nassau, Suffolk, and Westchester counties, it's going up to $14 per hour from $13. In New York City, that area maxed out last year, so there's no change to the $15 per hour minimum wage in New York City. Fast food employees have a higher minimum wage rate. Fast food employees are essentially employees who are working in restaurants that are part of a chain where there's at least 30 locations nationwide. Those employees outside of New York City need to be paid at least $14.50 per hour effective December 31st. And again, no change to the $15 minimum wage in New York City. Next slide, please, Kathy. One other development that happened kind of gradually over the past year. So effective on June 30th, the tip credit for employees covered by the miscellaneous industries wage order was cut in half. And effective December 31st, that tip credit is completely being eliminated. So essentially, employers who are covered by that miscellaneous industries wage order, who have employees who receive tips, such as car wash attendants, nail and hair salon workers, dog groomers, valet parking attendants, those employers can no longer pay essentially a sub-minimum wage effective December 31st and count tips received by customers as part of the minimum wage. Those employers have to pay the full minimum wage regardless of tips received by employees directly from customers. This change does not impact the tip credit for food service workers and other tipped service employees at hotels and restaurants. Those employees are covered by a completely different set of regulations called the hospitality industry wage order, and the tip credit has not been eliminated for those employees. Next slide, please, Kathy. In fact, the tip credit for the hospitality industry in areas outside of New York City is actually going up. So in Nassau, Suffolk, and Westchester counties for food service workers, employers can count up to $4.65 per hour received in tips toward the minimum wage. And for the rest of New York State, outside of New York City, Nassau, Suffolk, and Westchester counties, employers can count up to $4.15 per hour as a tip credit. Service employees, so those employees are non-food service workers such as housekeepers in hotels, luggage handlers, those sorts of employees who don't serve food but also receive tips in the hospitality industry. There's a slightly lower tip credit, but it is going up again in Nassau, Suffolk, and Westchester counties, and going up a little bit in the rest of New York State as well. Next slide, please, Kathy. The minimum salary levels to qualify for the executive and administrative exemptions are also going up. So in areas outside of New York City, Nassau, Suffolk, and Westchester counties, it's going up to $937.50 per week. It's going up to $1,050 for employers in Nassau, Suffolk, and Westchester counties. And it's holding steady at $1,125 per week for employers in New York City. For those employers who provide meals or housing to their exempt employees, you can credit that. You can credit the value of meals and housing toward the minimum salary level in New York State. You should probably consult your legal counsel before you do it, because you may not be able to count the full market value of the meals and housing. So just to make sure that you're counting it appropriately, you should talk to your legal counsel, but you can count some of it. Next slide, please, Kathy. There is no salary requirement in New York State for the professional exemption, but remember that the federal salary requirement for the white collar exemptions, executive, administrative, and professional, went up to $684 per week effective January 1st, 2020. That is still in effect, and employers in New York State have to make sure that their professional employees meet at least that federal salary threshold. Unlike New York State, that federal salary threshold is exclusive of board, lodging, and other facilities. So you cannot count the value of meals and housing toward that $684 per week for purposes of the federal minimum. There's certain types of employees who are professionals, regardless of whether they're paid on a salary basis or regardless of their salary level. So teachers, doctors, lawyers, medical interns and residents, those are all exempt just by virtue of the duties as well as their professional accreditations, regardless of the salary level or salary basis. Next slide, please, Kathy. Remember that the salary levels are only really half of the analysis when it comes to determining whether someone's exempt. All employees to qualify for an exemption have to meet one of the duties requirements as well. These are a very brief rundown of the duties requirements for the administrative and executive exemptions. For the administrative exemption, the individual has to perform office or non-manual work. It's got to be directly related to the management or general business operations. And the employee has to exercise discretion and independent judgment with respect to matters of significance. For the executive exemption, the employee has to be engaged in the management of the enterprise or a department or subdivision. The employee has to direct the work of 2 or more employees. And the employee has to have the authority to hire and fire, or at least make meaningful recommendations about those sorts of employment decisions. Next slide, please. There's 2 types of professional exemptions. One is the learned professional. Those employees essentially perform work that requires advanced knowledge in a field of science or learning that's customarily acquired by a prolonged course of specialized intellectual instruction. And the creative professional performs work requiring invention and imagination, originality, or talent in a field of artistic or creative endeavor. As the salary levels go up, it's always a good time for employers who have employees who are in one of these exemptions to not only evaluate the salary, but also kind of take a fresh look at the duties. Look at whether the job descriptions have changed, whether the duties have changed, and just make sure as you're evaluating whether people meet the minimum salary, whether people are also meeting the duties requirements as well. I'll turn it back to Pete.
Thanks, Suba. A lot in there. I think, with all the different thresholds and the different triggers depending upon geographic areas, to the extent that employers have operations in different portions of the state, they're really going to have to keep their eye on the ball here.
Yeah, I agree. Yes, you got to make sure you meet wherever the employee works is the relevant minimum wage that has to be met, or the relevant salary level for the exemption that has to be met.
Okay, great. Thank you. So I'm sure we'll have questions in the next couple of weeks on that from our clients. Let's turn now to Katie Anderson for the weekly update. Unfortunately, or it's a sign of the times that it appears that there's a lot going on pretty much every week. So Katie, take it away, please. I think Katie's frozen. I'm not sure if we've got an issue there. I'm going to suggest we call an audible here and go to Andy Bobrecht. Kathy, if you could go forward through Katie's slides. We'll come back to Katie in a few minutes when she's back with us. Hopefully we'll get that worked out. So Andy's going to talk a little bit about some recurring issues. We've had a lot of issues that keep popping up, and it tells us that they're of significant interest to our clients. So we thought we'd hit a few of those today with Andy Bobrecht.
Thanks, Pete. Good to be with you. Good to be with everyone here. So this list is not exhaustive, that's for sure. I know all of you have all sorts of issues on your plates and desks right now with respect to COVID and personnel and employment issues, among others. But these are a few things that have continued to come up that we're hearing from our clients that we're working with them on a fairly regular basis. So we wanted to reiterate some of these points. Probably right now, with the prevalence of positive tests, contact tracing, potential exposure, the issue that we hear perhaps most frequently is what do I do where my employee, for example, has been exposed as someone who tested positive for COVID and reports this per our instructions, or they report having COVID symptoms. What do we do in these situations? Well, first and foremost, you want to have your infection control and safety plan that we developed way back when, and have that ready and able, and have those procedures set and follow them. In these circumstances, additionally, the state has set forth very detailed guidance and steps that employers need to follow. Again, whether they have an employee who tests positive, whether it's somebody who's been traced and had exposure, or somebody who's reporting symptoms. And so you're going to want to have those bits of guidance together and to follow them. I would just note that there is particular steps that healthcare institutions, nursing homes, and education institutions, schools, primary and secondary schools need to follow. So act promptly, follow those steps. When in doubt or when you have questions, contact legal counsel, and we can certainly work with you on that. Holiday travel is another issue that we certainly dealt with over the Thanksgiving holiday, and we're going to be dealing with again. The message is generally out there discouraging people from traveling during the holidays and to help stem the spread of COVID and reduce the infection rates that we're seeing continue to climb. From an employer standpoint, this can raise a number of issues, both legal and practical. But I think in general, we've seen lots of different approaches to, again, consistent with the desire to maintain infection control, keep workers safe. and to, I think, appropriately discourage employees from traveling where we can do that. And I think 2 points are salient here. One, that the state has made clear that if an employee travels for non-work related reasons to a non-contiguous state or to a country that's been designated as either a level 2 or level 3, they can have that right risk, then they are not eligible for the COVID-19 paid sick leave benefits under state law. So communicating that point to employees, I think, can be an effective, first, it's accurate. It can also be an effective deterrent and clarify a misunderstanding that an employee may think, hey, I can use my vacation to travel to a state of high incidence and come back and I'll have another, up to however many days of paid leave under the state statute. Again, that's not the case, and communicating that interpretation that the state has given can serve as an effective deterrent, and again, helping to keep everyone safe. As a side note there is a separate issue as to whether the FFCRA would apply in that circumstance, and one of the EPSL criteria could apply. So if that does come up, you're going to want to work with your bond attorney on that matter and make sure you have the correct analysis in place. Just as an aside, I took a look at the CDC stats this morning for the high average daily rates of infection or positive tests over the last 7 days. And I was surprised by the states who were on there. The top 4, again, over the last 7 days were Ohio, Indiana, Rhode Island, and Tennessee. So again, keep those states in mind. Again, from New York's standpoint, the prohibition applies to all non-contiguous states, but those states in particular were noted as high. The lowest right now was actually Vermont, had the lowest daily rate. So I wanted to pass that along as well. Remote work too. Again, I think remote work is not going away anytime soon. I think it can work great in the right circumstances and with the right people. It's not going to work in all circumstances. It's not going to work with all employees. I think we have to be mindful to continue to monitor the performance of remote work, make sure that it's working for us. We obviously want to be fair. We want to be flexible with our employees, but we can't have that flexibility supplant accountability or responsiveness. We still need to operate as an organization, as an entity. We need folks to do their jobs appropriately, even when they're working remotely. One effective device to, I think, both set expectations appropriately and as well as have there be a documentation of the process of how accountability and review will work is to have a remote work agreement. I know I've worked with several clients to develop those types of agreements, and I guess you could pick one off the internet that you might find, but I would really recommend against doing that. It really needs to be tailored to fit your particular business, to fit the particular job, and there are both state and federal legal issues that can come into play when drafting those documents, so proceed carefully. Unemployment, again, we're seeing more discussion about this issue. Now, the $600 extra payment that expired earlier this year, but the additional eligibility criteria under the PUA is still in effect. And in fact, it'll be in effect until I think the 26th of December. But after that point, we're going to be right back to the good old-fashioned unemployment, as I understand matters. So keep that point in mind if you're looking at certain personnel decisions, operational decisions, and what benefits are out there in terms of unemployment for individuals who may be impacted by this. Again, that broader range of criteria that allowed an individual to collect unemployment where they otherwise wouldn't is set to expire at the end of the year. Last I checked, there hadn't been any developments on this. I think it is possible that we see something done to extend this or provide some type of comparable benefit as part of the stimulus package under negotiation in Washington. There's been some talk about an additional $300 payment as part of a compromise. But again, nothing that I've seen firm and final on that. So stay tuned. We'll, of course, report back if we do see anything. Also, social media. I think it's important to mention this. This is something that I've seen come up with a number of clients in a wide range of circumstances, but where there may be an employee who is being critical of the employer or the business or the organization, or certain things that are happening at work or involving that employee. Whenever we see that type of conduct, I think there is this initial reflex that, hey, we need to do something about this. This can't happen. This makes us look bad, or we're concerned about the messaging or how the public will interpret this. All are very appropriate concerns to have, but we do need to exercise a measure of caution when addressing these issues in a number of fronts. Where we see a lot of the regulatory activity and enforcement concern is with respect to the National Labor Relations Act. Under that act, employees can engage in concerted activity for mutual aid or protection. So again, they're raising a work-related concern with some eye toward a group action, or trying to address it or fix it or bring it to the public's attention so that it can be remedied. In that situation, employees are protected from any adverse employment action where they engage in that concerted activity for mutual aid or protection, and that can be done through social media. Now, there are boundaries to the conduct where the law no longer protects the individual depending on what they said, how they said it, and what the circumstances were. That's going to depend on legal analysis, and you're certainly going to want to have that addressed and analyzed with your bond attorney before taking any action. Not a bad time either to take a look at your social media policy. And if you haven't had that updated in recent times, I would encourage you to do that now. Could well be that we're going to see more and more of this type of activity as circumstances continue to be challenging here in New York and across the country. Finally, Pete, just a few non-COVID details. Suba covered some of these already. These are things I just don't want people to lose track of while we have our eye on all things COVID. Remember, if we're going to be implementing pay changes at the end of the year, we're going to want to make sure we provide appropriate notice to employees about those pay changes in compliance with the Wage Theft Prevention Act here in New York. Also been working on a bunch of handbooks lately. Just a reminder, if you haven't updated your handbook policies in the last year, you're going to want to do that. There's a series of new laws that have been enacted that will require you to make changes in your handbook or to your policies. Those include additional protected characteristics that you're going to want to have referenced in your EEO policy, changes to your sexual harassment prevention policy based on legislative changes. You're going to need to have a reproductive health decision-making policy in your handbook in writing. You may not have that. I've seen several handbooks that don't have that included. And also voting leave. If your policy was recently amended, there's a change in the law. Again, we're going to need to re-amend that as well in your handbook. And finally, don't forget about paid sick leave. I'll give another plug on that. Teresa covered it great, but we're getting down to the wire on that. And if you haven't addressed it, now's the time. Pete, I know that was a lot. Hopefully it helps some. Thanks.
No, thank you. That is a lot to keep our eye on, but we're here to help if people have struggles with it. Okay, so now once again we're going to try to go to Katie. I would just comment, we've had a few challenges behind the scenes, mostly for this webinar from a tech perspective, but Katie just went poof there, so now she's back and here we go.
Yeah, let's see if my computer doesn't shut down on me this time. That was concerning. So I'll be checking on what happened there after this. So that's fun for me in this afternoon. We have a big day yesterday. Pete alluded to this at the beginning. Good news, vaccine distribution began yesterday and actually began being implemented. 10,000 doses were given to people yesterday. There are more being given across central New York today. I know that Upstate Medical Center is currently giving their first doses right now. We are expecting that Moderna's vaccine will be approved this week by the FDA. Once that's approved, there's going to be about 350,000 that will come to New York from Moderna. So the vaccine is here, it's coming slowly for, a lot of us, but for other people, it's coming very fast. This is an incredible turnaround that we've seen. Second thing that was a big thing in Albany was the Electoral College did meet yesterday. And that is always a big day in Albany. It was less big than it usually is because of COVID, but I thought it was worth mentioning. Turning to what's happened in the past week, I'm going to actually work backwards with what's happened. Last actually had Executive Order 202.82. This order is very long, very extensive about who can give the COVID-19 vaccine. It includes people such as dental hygienists, podiatrists, and midwives. And it also expands where vaccines can be given. It's not necessarily just your regular doctor's office or a hospital. It could also be your dentist's office. So that is a big change. It's tied to that vaccine distribution network of the fact that Pfizer's vaccine has to be kept so cold that, they're just trying to expand who can give the vaccine to get it out quickly. Turning then to Executive Order 202.81, the commercial eviction moratorium was extended until January 31st. That is my birthday, so everyone should remember that date. It also allows hospitals, and this is implicating nursing homes really and adult care facilities, allows hospitals to discharge patients who have not received a negative COVID test, so long as that patient is beyond their infectious period, which is measured by the CDC, and that person can be transferred only to a COVID-19 positive only facility, so long as that facility first certifies that it can properly care for that patient. The other thing that this order does closes indoor dining in New York City. It also implicates orange zones, and I'm going to discuss that at the end with what it does there. There are now new metrics for cluster zones. So we finally have reached the cluster zone update of this piece. These metrics have been changing and we finally have them. What they mean will remain to be seen. But first, a red zone can only be implemented when a region. So I bolded region and geographic area on the slide. I'll interrupt myself to explain why. Regions, remember, regions are the big zones. It's the Finger Lakes. It's central New York. It's Long Island. A geographic area are places within those regions. So it's Rochester. It's Hampton Bays. It's all of those types of things. But what's big about a red zone is a red zone it impacts the whole region. And that's big. And that region gets put on New York on pause, basically. A red zone will only be implemented when after you've had the cancellation of elective procedures and hospitals have increased their hospital capacity by 50%. Okay, so that's the baseline. After you've had those changes, if the region is still 21 days away from reaching 90% hospital capacity on their current 7-day growth rate, they will become a red zone. That's very different than the prior red zone designation, and there are currently no zones that qualify. We will need to receive more data in order to be able to more accurately predict when these red zones will pop up, especially about when and where regions are going to be canceling their elective procedures and where they have to increase their hospital capacity by 50%. The only region as of now that has to is Erie County had to cancel their elective procedures. Orange zones. Orange zones are designated when a geographic area there's one of two ways to become an orange zone. One, you either have a 4% positivity rate, which is a 7-day average over the past 10 days. That's a lot of numbers. And that area has reached an 85% hospital capacity. That's where they're at. Or, and this is the fun one, the Department of Health, the State Department of Health determines that the rate of hospital admissions is unacceptably high. What does that mean? We don't know. But those are the metrics, and the orange zones have not changed. They are the same that they were at the last update of the clusters, and they will likely remain that for a while, given what's going on in those areas. There are new yellow zones, but first I'll discuss how we measure the yellow zones, how we implement them. It's a 3% positivity rate with a 7-day average over 10 days. And that area is in the top 10% in the state for hospital admissions per capita over the past week, and is experiencing daily admission growth each week. There's a lot of data there. There's a lot of data in each of those three new metrics that I laid out. And we simply don't have that data easily accessible at this point. Perhaps by next week, we will have more of it available, but at this point, it's difficult to be able to tell, especially that per capita rate, what's happening. So that is the update there. It is confusing, and I'm sure there are lots of questions about it. I have lots of questions too. Turning to the new yellow zones, that were designated. We had Oneida County, which focuses on Utica and Rome. Niagara counties was expanded further north, and Genesee County focuses on Batavia. Those maps are now available on the website, and we will be putting out an information memo with our whole list of all of the maps, hopefully soon. I believe I have one more slide. Yes, the changes in the orange zone. Gyms and personal care centers, which is a very broad definition, may reopen, but they have to. This slide is actually the wrong slide. I sent a new slide over, so ignore this slide. Can we just go to the next slide? Because I don't even want people to look at this slide. It's wrong. Perfect. Yeah, that's fine. So for gyms and personal care services, this is what's happening. Everybody can, in an orange zone, go back to work, but there are certain things that need to be done. One, gyms and fitness centers can only operate at a 25% capacity. Two, for personal care centers, which is a very broad definition, that they can reopen, but one, before they reopen, every employee that has direct contact with customers have to be tested for COVID and have a negative test within the 7 days that they're going to be reopening. So if you're going to reopen on Thursday, everybody will have had to get negative tests that week before. And then while you're still operating, your employees that are having those direct interactions with customers need to be tested every week while you're in the orange zone. Currently, those capacity limitations don't apply. That 25% capacity limitation, that does not carry over to personal care centers. That is gyms only. But gyms don't have to do that testing regime that personal care centers would have to do. Again, it's a very broad definition of personal care centers. With that, my glitchy presentation is done.
Katie, thanks. I just can't get over the original image of the governor with the valve. There are just so many valves now. It's like a master control room with, hundreds of valves being opened and closed and adjusted. So we'll just have to see. Okay.
Yeah, he had that valve up on the presentation yesterday, so it's back.
Yeah. Yeah, originally it just seemed like it was just one, the blunt instrument, open or close. But we've really, we've honed it down to a lot of different metrics in a lot of different places. Okay, so we did have some questions. We had planned this with Kate before getting the questions, but we've had questions in the chat here about, what's on the horizon. I think, also probably looking back just a little bit too. So Kate, please take it away.
Thanks, Pete. It's great to be back today. So yes, there is relief package on the horizon. I know many people here on this call have heard me say that before, and nothing happened. It all kind of fell flat. But we're saying it again. There was new text released late last night regarding the current proposal that's on the congressional floor, which includes a few different things. First off, there's no individual stimulus payments to Americans inside the package. So in the last relief package, there was the $1,200 payment. There's nothing in the current package for that. It's a point of contention between the various parties negotiating the relief package. So stay tuned. It may still happen. It may not, but it is a point of contention. The other two big points of contention right now holding up the relief package is the liability protections for small businesses and payments to state and local relief packages, payments to state and local governments. So those are really the three big hangups right now on getting a package voted and agreed upon. We're hearing that the deadline, so to speak, of a package is this Friday because they're trying to tie it with a spending package. So we'll see. The clock is ticking on what will end up happening. When it comes to the PPP, there is actually quite a bit of changes for the PPP included in the package that was released last night. So I'm going to talk a little bit about those right now. Keep in mind, again, this has not actually been passed yet. So anything that I'm going to talk about here in the next couple of minutes is still in the proposal stage and may not happen, but some things to think about that may happen here within the next few days. So the first big part of the changes to the PPP included in this legislation is that there'll be a second round of funding. And that second round of funding is very narrow. So it's going to be for businesses with 300 or fewer employees that actually sustained a revenue loss of more than 30% in any quarter in 2020. So those are going to be your two metrics for a second round of funding. And I'm just summarizing. There's far more in this legislation than what I'm going to talk about here in the last couple of minutes of our presentation today. There's also targeted relief for businesses with 10 or fewer employees. There's targeted relief for operators of live venues, so things like theaters, entertainment centers, stuff like that. There's also going to be targeted relief for underserved communities and disadvantaged businesses. One of the big changes to the current program is an expansion of how you can use your PPP funds. So right now, you've heard me say it a million times, it's payroll expenses, certain employee benefit expenses, so your health insurance, your 401k, retirement, your non-payroll expenses, so your rent, mortgage interest payments, utilities, that's going to be expanded in the new bill if it gets passed and there's no changes, which there probably will be. But it's the stuff that they're going to be adding is going to be personal protective equipment costs, so your PPE. There's going to be an allowance for certain upgrades to your buildings. If you needed to go and put in new ventilation filters and stuff like that to enhance your cleaning protocols with regards to COVID, that type of stuff is also going to be included in your eligible expenses. But the threshold for using the majority of the funds on payroll expenses is still in place. So keep that in mind too. Even though we're expanding how you can use the funds, you still have to use that 60% threshold. The other really big news would be the simplification of the loan forgiveness process for borrowers who have loans under $150,000. So that process is going to be, if this legislation moves forward, greatly simplified. It appears like it's going to be more like a one-page certification that you've complied with the rules of the program and then move towards forgiveness. So that'll be great news for borrowers with those smaller loans. And the other big piece of this is regarding the taxes. So there was the IRS guidance that was released within the past month regarding the deductibility of the cost of wages and other expenses that are paid for using the PPP money. The new legislation, if it's passed in this language, stays in it, reverses that rule or overrules that rule that the IRS created. So it would allow businesses to both, take their PPP money and take their normal deductions. So that I think is good news for a lot of our clients who've had questions about that piece. So that's a very quick overview of what we're seeing with respect to the PPP and the new relief package. There's other things in there as well, not related to the PPP, but we want to focus at least on PPP today. A few other quick updates. We were seeing a lot of questions about the loan necessity questionnaire that was released. Keep in mind, that's only for borrowers who have loans over $2 million with their affiliates. So that's not going to, if you don't have a loan over $2 million, you don't have to worry about that loan necessity questionnaire. There was a frequently asked question released in the past week, clarifying the SBA's position on that loan necessity questionnaire, who has to fill it out and why. So we did see that update. Anybody who's read my update sent out by the firm saw my article on this a couple of weeks back, questioning the loan necessity questionnaire and the fact that it asks questions regarding what actually happened to your business, not just what you anticipated would happen. The SBA did acknowledge that is the case, but they're looking at it as a totality of the circumstances, and they're not necessarily going to hold it against a business if they did better than expected. So we did see that clarification come out from the SBA. And the last piece I just want to talk about quick here in the last minute is the other question we've been seeing a lot is, when do I apply for forgiveness? So I think there's a lot of circumstances really right now to think about when you're thinking about applying for forgiveness if you haven't already. One being this new legislation. I just talked about some big changes that may happen, particularly for loans under $150,000. For those borrowers, they may want to wait and see what happens if there is new legislation that's more favorable to the loan forgiveness process. For borrowers who are potentially looking at future layoffs being made, they may want to get the loan application process done and out of the way before they make those layoffs. For borrowers who are looking at selling their business before in early 2021, are looking to start that process. Keep in mind, the SBA released guidance regarding what to do when there's a change in ownership of business with a PPP loan. So you may, in that situation, want to apply for forgiveness, get that loan off the books, and get your forgiveness taken care of before you sell. So there's various considerations to think about now here at the end of the year with all these pieces in place. And of course, we're here to help if you've got questions about when to apply and what really works best for your business, because like I said, it really is a very business specific analysis. All right, I know that was a lot, but that's the quick update. Hopefully next week we'll have a little bit more information on some new legislation. Pete?
Okay, thank you, and thanks everyone for being with us today. Again, we appreciate it. We appreciate you, and we look forward to speaking with you next week. Have a good week.